Why don't you go, since...
My question is in relation to the discovery you were just touching upon. When the decisions are made about how many depositions are going to be taken, how many are going to be allowed, what kind of discovery is going to be allowed, are these decisions made at the beginning of the arbitration, or are they mandated by the different arbitration organizations that particular companies are using? Like, how are those decisions made?
It varies. FINRA, for example, which deals with securities industry employment arbitrations, doesn't allow for depositions except in really extreme circumstances, if there's a witness who's on their deathbed. The AAA generally leaves it up to the arbitrator. So the parties sometimes in their arbitration clause can address the situation ahead of time. It's usually drafted by the employer, but it might say each side is entitled to 1 deposition or 2 depositions. That's possible. It's not that common. Usually, at the end of the day, it's up to the arbitrator. And it's usually decided early in the case, in one of the initial calls that you usually would have with the arbitrator. Parties will either agree on whether they want depositions or not, and if they can't, they'll have to make their case to the arbitrator as to whether or not depositions are appropriate, and you really get the gamut of responses to that depending on the arbitrator.
That's one more question. Just to follow up on your testimony, do you think it would be beneficial for us as a legislature to look at limitations to those types of agreements? Obviously, if you're either an uneducated consumer or if you're somebody who's just looking to get a job, you're not thinking about down the road what's going to happen. Clearly, companies have the upper hand, and they want to arbitrate these claims. They want to do it quickly, efficiently, as quick as possible. I understand that. But to me, it seems fundamentally unfair to limit and to cut off, even pursuant to agreements, especially if both sides are not aware of what's going to happen, to cut off the findings of fact. I mean, that's what getting to the right answer is supposed to be. It's supposed to be a fact-finding mission, and then the two sides can come to the conclusion about where they're going to end up. It seems to me that limiting discovery without knowing what the outcome is going to be, that's very dangerous. Is that an area you think that we should look into?
I think it's worth considering, but I would have some hesitation about the legislature mandating that deposition discovery, which is what we're talking about, be equivalent to what it would be in court, for example, or at least federal court, where there's a limit of 10 for each side. Because there can be some benefit to a plaintiff, an employee as well, to having a more streamlined arbitration system without depositions. It's not necessary, it depends on the case, it depends on a lot of things. I'm not sure that's necessarily something the legislature would want to step into. But what I do think would be significant is if there's not going to be depositions equivalent to what would be available in court, there shouldn't also then be the availability of summary judgment in arbitration without an actual arbitration hearing. That, to me, is fundamentally unfair. If you're not going to allow a full scope of depositions, fine. At least in some cases, I'd be okay at least leaving it within the discretion of the arbitrator. But you shouldn't then be allowed to get the same mechanisms that are available in court that are really designed to deal with a situation where you've had the full scope of testimony from the relevant witnesses already.
One question. Could you comment on the prior witness's assertion that if folks don't want to sign these agreements, they can simply find a job elsewhere?
Yes. I've been practicing in this area almost 20 years. I'm guessing my colleagues who are sitting behind me would say the same thing. And as well as litigating, I've negotiated many employment contracts. I've yet to have anyone say, if they don't take that arbitration clause out, I'm not taking the job. So as a practical matter, even if maybe in some cases the employer's willing to negotiate aspects of an arbitration clause, I have seen that. I've yet to see an employee be able to say, have the leverage to say, that comes out, or I'm not here. And then on top of that, to have an employer say, no, I'm not taking it out, and the employee say, well, then I'm not taking the job. It's sort of a fiction. It doesn't happen. Even if an employee doesn't like the arbitration clause, no one's expecting litigation, so it's not something somebody's typically going to be able to say or afford to say, I'm not taking the job over that. And I think, as you commented, they're becoming so prevalent that it's not necessarily the case that you can just get a job somewhere else that's not going to have one. I mean, certainly, I don't know if there are statistics on this. I haven't seen them. I mean, there are plenty of employers who don't use them, but they're becoming, very, very prevalent.
Certainly the entire securities industry, they're
Yes.
mandatory. Yeah.
Okay, thank you very much.
Thank you.
Next is Johnson Tyler. Good afternoon. Do you swear your testimony will be the truth?
It will be. Thank you. I would add to what Mr. Steck asked, try not signing an arbitration agreement on your cell phone service and you don't get a cell phone. They don't care. So thank you very much for inviting me to testify today. I work at Brooklyn Legal Services, which is one of the borough offices of Legal Services of New York. Legal Services of New York is one of the largest, or is the largest legal service provider in the United States. We help 25,000 low-income people every year. In the area of consumer law, we've been long litigating cases involving predatory lending, predatory credit cards, debt relief scams, and we've come across arbitration clauses in the last 5 years. And I'd like to tell you the first story involving a client of ours. There's a statute in the United States written in 1996 that basically says if you try to entice someone into your services to increase their credit score and you take a fee from them before achieving that, you violate the law, you have to give all the money back, they're entitled to damages, and you get attorney's fees. It's a very simple statute. A client of mine came to me and had been ripped off by a debt settlement company. These companies were prolific in 2008, 2009. They offered basically to get rid of your credit card debt. There were over 2,000 of these companies in the United States. The Federal Trade Commission issued rules trying to regulate them. There were over 200 attorney general actions involving these cases, these sort of debt settlement companies. So I was like, okay, let's litigate this case. It's a very simple case. We went to court. We were aware that there was an arbitration clause. There was a split between the circuits as to whether it was enforceable. And we got there, and we discovered a number of things. One was that the debt settlement company that we've been litigating had been investigated by 5 different attorney generals. There had been 3 actions against them by attorney generals. There were complaints in 18 different states. They were operating all across the country. There was not a single lawsuit against them. They invoked the arbitration clause. We got kicked out of court under those grounds. We tried to arbitrate. By that point, they'd actually been put out of business by Arizona. But later on, we were aware of this database, the database that California has. It's very similar to what you've proposed today. The company here that ripped off 2,000 to 3,000 people was the product of a lot of investigations, 3 arbitrations against them, and only by one of the most experienced law firms involved in litigating cases against debt settlement companies. Within the field of debt settlement companies, I mentioned there were 2,000 of them. There are only 7 cases reported in the United States in the court system, of which 5 got kicked out due to arbitration clauses. The arbitration clauses are very useful ways to insulate businesses that are designed to make money off of, by deceiving people and avoid both state laws and federal laws designed to protect consumers. So having had this experience with this bad arbitrator, and by the way, they also had a forum selection clause, which said you have to actually come to Arizona to arbitrate your claim. My client was low income in New York. She had $700 a month of income. She could not fly to Arizona, stay in a hotel, arbitrate a claim there. So, and that case was upheld because of Supreme Court jurisprudence in the Second Circuit. That decision that she could not even force an arbitration in New York. So having lost this case, I thought, well, let's see how bad arbitration can actually be. I had another client purchase a product from a well-known company that was bad. She had tried for quite some time to get her money back. It was a mattress with bed bugs in it. They would not give it to her. They would not listen to her. We filed the arbitration claim. Immediately, we got an offer to try to settle the case. So I was like, well, how do I figure out whether to settle this case? I used the database that California has that we're proposing, you guys are proposing to emulate here. It showed that in only 20% of the cases did this company actually pay claimants. And a number of those cases were huge figures, so they must have involved some sort of personal injury that was astronomical. In other words, 80% of the time, people going to court, going to arbitration, were getting nothing, $0. So we ended up settling that case. The problem, that illustrates really how the arbitrators are in the pockets of the businesses that hire arbitrators over and over again. That company had 172 arbitrations on record in that database. So they are a big player among the AAA arbitrators, or actually a modest-sized player. But that sort of discrepancy in sort of outcome, if you compare that, you can look, there's studies that show that if you go to court, you're going to win between 36, a claimant will win between 36 and 71% of the time. So it's a big difference, arbitration there. So addressing the bills that you've proposed today, I think the portion of the bill that requires the arbitration agencies to release data about the outcomes is really important. California already has it, and one of the shortcomings of California, the legislature there actually put out a study, and it's cited in my prepared statements here. One of the shortcomings is that the arbitration agencies don't follow the law. They don't put the information in. And consequently, there has to be a private right of action here to have that happen. Maryland has passed a similar law to what is being proposed here on the revealing details of arbitration. It has a private right of action to it. I cite that in my prepared statements. That could be used as a model to include that. There's one other thing that I think is important and other people have not addressed here, is that arbitration, in my experience with my client, which albeit is simply one, arbitration is not an all or nothing thing. I am sure that arbitrators are leaning on people to settle cases. Does that constitute an award? There are a huge percentage of those California reported cases that don't have any award number in them. So they're absolutely meaningless. So I think you should modify the terminology within the legislation so that award would also include settled amounts, because the arbitrators often are aware of what the settled amount is. If it simply is what is awarded, it may not be ordered via a decision by an arbitrator. And that would capture much more the value or lack of value of the arbitrations going forward. That's the end of my prepared statement, and I'd be happy to answer any questions.
Questions? Any questions? Any questions?
I have one question.
Sure.
You've mentioned extensively the database in California. Are you aware, does the database in California store information about what arbitrators render decisions in particular cases? I understand that they'll collect information and data about the arbitration organizations, but how about the specific arbitrators?
Well, the database that I'm most familiar with is the AAA database. So every arbitration organization has to create their own database. What California found was a lot didn't even do it. AAA actually does provide you the names of the arbitrators, so you can actually search by arbitrator to figure out what their track record is. But AAA is, my understanding, is kind of the premier arbitrating organization. They, my understanding also is they don't really like doing consumer cases because it makes them look bad. It's a public relations problem. And just as the other very large arbitration organization got out of doing consumer-related cases, that may be the trend. But again, I think there is no one central place you can go and look at all of this data that gets aggregated. You have to go to each of the arbitration websites to get it. And the California statute itself does not require, if I'm correct, I'm pretty sure I'm correct, it does not require the name of the arbitrator. I believe AAA actually added stuff to make it more user-friendly and more revealing. But again, most of the information, when you look in even the AAA database, the fields are empty, and they're empty on the award amount 90% of the time. So that makes the data not very useful.
Okay. Thank you very much.
Thank you.
Russ Haven. Good afternoon. You swear your testimony will be the truth.
I'm Russ Haven, Legislative Counsel with NYPIRG. We appreciate the opportunity to share our perspectives on this important issue today. I'll try and summarize things. From NYPIRG's perspective, we consider consumers to be not only consumers who go out and purchase goods and services, consumers of health care, employees, small business owners who also may be caught up in what we consider to be arbitration overreach. The unifying feature of these contractual arbitration provisions, sometimes called mandatory binding arbitration, we're going to call it forced arbitration because that's really the most succinct way to call it, is that they are adhesion contracts. And when I saw this, I realized I should go back to Black's Law Dictionary because I haven't looked at this in a long time. So I've included in the statement what that means, and here's how Black's Law Dictionary defines an adhesion contract. A standardized contract form offered to consumers of goods and services on essentially take-it-or-leave-it basis without affording consumer realistic opportunity to bargain and under such conditions that consumer cannot obtain desired product or services except by acquiescing in form contract. Distinctive feature of adhesion contract is that weaker party has no realistic choice as to terms. That really captures what we're talking about here. As a result of a series of Supreme Court decisions, some of which you heard described today, the expansion of the Federal Arbitration Act is, I think, been exponentially expanded, I'm sure beyond whatever the drafters originally envisioned. As a result, the Supreme Court's outsourced to a private system that has no interest in nor obligation to the process of substance or substance of justice, important rights and important decisions that affect the lives of everyday people. In short, forced arbitration bears none of the hallmarks of a fair dispute resolution process and is not even in the same galaxy as the founders' ideals in setting up our tripartite form of government. Machiavelli would be impressed at the hijacking of our judicial system. Kafka would be stunned. As a result, these clauses are now ubiquitous, so they're showing up in, as we heard, cell phone contracts, online travel services contracts, internet provider contracts. With respect to financial products, auto loans, credit card agreements, consumer loans, student loans, health care, nursing home contracts, as we heard. Others talked about hospital contracts. I haven't seen that then, but I would not be shocked. And obviously in the workplace, in products, there's certainly computer sales and other kinds of products. one of the more recent and deeply troubling Supreme Court decisions is the Concepcion case, AT&T cell phone case. And basically, the U.S. Supreme Court gave its stamp of approval for forced arbitration clauses that remove the ability of consumers to organize together and proceed as a class, as we've heard, particularly when the financial losses are small and the potential of engaging in discovery to develop your case are big. That's a staggering loss to consumer protection. The fact, as we also heard, in that the CFPB details in its 2015 report, that few consumers actually go to arbitration underscores the importance of organizing as a class collectively to seek redress. Yet, essentially, again, the Supreme Court's blessed this. And I would note when Texaco and Getty are fighting over billions of dollars about whether or not somebody is engaged in predatory practices, they don't go to forced arbitration. What do? They go to the federal courts. If Apple and Google get into a fight, you know they're not going to arbitration. They're going to use the federal courts. So it creates a two-tier justice system where wealthy corporations who benefit from these clauses choose to have their high dollar amount cases resolved in the courts and would never go into an arbitration situation. And obviously, this is not like A-Rod in Major League Baseball, where you have a strong, well-financed union, wealthy players on one side, and management on the other side. This is a far different system. But really, perhaps the most odious place where you see these contracts are in the nursing home context. And I just want to, put you in the position of someone who is going into a nursing home. They've had some event, a fall, or perhaps surgery, or they've had declining health. Sometimes they're on their own. If they're lucky, they have family or friends who can help shepherd them through the process. And at this time, they have to read through the contract. It's very hard to find a good nursing home. You have to find them that accept the coverage that you have. You have to find one that's convenient so your family and friends can check in on you. Every care provider group, support group tells you a key thing is having family and friends show up regularly so the staff knows someone is monitoring your well-being. And there's also the emotional distress of trying to make these decisions. And in that context, you're supposed to somehow fly-spec a several-page or maybe dozens of page agreement, and then pick out the arbitration clause and then fight over it successfully, negotiate it out. And I can tell you, this is not an academic issue for me because I went through this exact situation 3.5 years ago. I went through it in another state, but we had to move my mom out of surgery where now they want to move you out very, very quickly. And so we found out on a Saturday we had to have her in a nursing home by Monday, and they were not taking any ifs, ands, or buts about it. And we were flipping out, and this was left. First of all, we were wondering if she was going to make it through the surgery. She was 89. She had dementia. These were no small set of concerns. We had to find a place, and when we finally found a place that seemed suitable, I negotiated. I actually did that. I read the contract, and I told the facility manager that as a consumer attorney, and my mom taught me my first consumer lesson, which is when you get screwed, make a scene in Macy's window, and that usually will get you some relief. She wasn't always right, but it's not a bad tack. But so I felt I had to go through it, and I fought with the guy, and basically I put a line through it, and I said, I'm not going to sign this. And he said, don't worry about it, I don't care. And he was a new guy and a trainee, but in that case, I did that. In most cases, you probably couldn't get away with it. It wasn't actually that blunt as I recollected. I think I negotiated back and forth. I said, look, I'm really uncomfortable. I want to strike this out. And he said, don't worry about it. But I doubt that's a typical interaction. P.S. The story does not end happily. My mom passed 3 months later of sepsis, which certainly seems that the quality of care she received was not great, although there was no way we were going to start a personal injury action in the North Carolina courts. But you can see just how bad this is. And the other thing is that the public's interest is damaged. Public interest is damaged because the whole situation of what happened to my mom and probably other residents is never going to get brought to light. There's no public forum, there's no documents, there's no way to really do this. One of the benefits of our court system, as we've heard, is that it's open to the public. The public can judge whether or not they're comfortable with the results, and these kinds of things come to light, not only for the general public and reporters, but enforcement agencies. And there's a good deal of information about how private civil litigation often leads to government action, that whether it's by being exposed to the information or being shamed to act, attorneys general, district attorneys, and others will take action only after there's a civil court action brought by people in some shape or form acting as private attorneys general. Just to sum up before we talk about, I talk about the recommendations, to really sum this up, with forced arbitration, the big business gets to choose the game, the location of the field, the playing surface, the game time, the cost of entries, the rules, and the referees, and they get to pay the referees in many cases. There's no reviewing a play to challenge a call. You have no real right to appeal. That's the definition in a nutshell of a rigged game, except this isn't a sport. As we know, what's at stake are people's jobs, their finances, and their well-being. Absolutely, you're doing a tremendous service by holding this hearing. We need to address this in New York State. And I think the work done by David Seligman and the National Consumer Law Center is absolutely the blueprint of where to start. You've heard some other recommendations to add to that. I just want to tick off in bullet summary some of the things that I think are particularly worth looking at. New York has enormous market power. We spend billions of dollars in goods and services. We should expect a higher standard of conduct. If you want to do business with New York, you have to clean up your act, and one of the things you shouldn't be doing is screwing people by a hidden arbitration clause in your contract. There's many other things we could be doing with our market power. This is certainly one of them. NYPIRG, and as you may know, we're part of a statewide coalition, which MFY is as well, called New Yorkers for Responsible Lending. We've supported the Assembly Bill 108, which would really help. The Heisenberg principle, sunshine is the best disinfectant. Get that data out there. It helps drive the press. It helps people think twice when they're looking at these contracts. It shames the businesses. And that's a good thing. Ultimately, we may be in for a long fight here in terms of building a consensus that these are unacceptable provisions, except when it comes to really level playing field, equal power negotiating parties. So we would support that. Again, I think the statewide coalition, I don't want to speak for the statewide coalition, but I think this is exactly the kind of thing they'd be supportive. More disclosure, flagging those things in contracts, the implications, people should be able to understand it. I once read somewhere where many of these kinds of contracts are written for graduate level students. People can't parse this. There are standard software programs that can tell you objectively what the comprehension and reading level you need to understand these things. Maybe there's a way to make sure that these kinds of provisions are at a level that most people can understand. And the state legislature presumptively declaring that there are certain terms that are unconscionable. As we've heard, it appears we would have to make this across the board for all kinds of contracts, regardless of the form. But perhaps that will knock some of these out and create a chilling effect where the businesses won't want to put them in. I thank you again for holding this hearing. Look forward to working with you and getting something done in this area.
Any questions? Great, thank you very much.
Thanks so much.
We've run out of witnesses, so I want to thank everybody who testified, everybody who came, and I know we have a lot of work to do. There were a lot of important issues that we care about, and we will be examining the testimony and other information during this legislative session to see what we come up with. And thank you to all my colleagues.
And likewise, want to thank everybody who testified or participated, and feel free, whether you testified or just was here observing, to, if you want to submit any information to the two committees, that we very much appreciate. Often someone who goes early hears something later on that makes, that they'd like to respond to, so we welcome your additional comments. Thank you.